Court of Justice is now in session. President Hans Correl and the Honorable Judges Eduardo Valencia-Ospina, Roy S. Lee, Gian Luca Berchi, and Morad Eghbal presiding. Is the matter of the state of Behestoon versus the state of Agistanus. The applicant and the respondent are each allocated 45 minutes to present their pleadings.
Who would be the agent for the applicant? Please go ahead.
May it please the court. My name is Alexandra Counsel. I appear in this court today on behalf of the government of Behestoon, the applicant in this matter, along with my learned co-agent, Ms. Fiona Gauntlet. I will be addressing the court today for 20 minutes. My learned co-agent will be addressing the court for 22 minutes, reserving 3 minutes for rebuttal.
Yes,
Mr. President, Your Excellencies. This case concerns the destruction of the Ozoonio River. The Ozoonio River supports the people of Behestoon. It is relied on for their domestic needs, certainly.
I'd like to ask you a question.
I would like to ask a preliminary question, and I think is one that I do more by way of clarification. I understand from the compromise, the agreed facts, that there is no question of jurisdiction before this court. Of course, the court has to satisfy itself that it is competent to hear the case and that the application is admissible before going into the merits. I understood that you and the other party are coming by a special agreement to this court. Is that correct?
Yes, both parties have submitted to the jurisdiction of the International Court of Justice.
Well, if that is the case, then why are you the applicant? Because when a case comes to the court by a special agreement, the two parties are in the same position. There is no applicant and there is no respondent. Does this mean that, in effect, you are arguing on the basis of your acceptance of the compulsory jurisdiction of the court under Article 36, in which case you would submit a unilateral application and you would properly be the applicant? But if you have come together by a special agreement, there is no applicant and there is no respondent. Could you clarify that?
The government of Behestoon is the applicant in this matter on the decision on the merits of this particular case, and not on the jurisdiction issue before the court.
Fine. I think I will not pursue the point, but it may be useful to keep this in mind, that when you come by a special agreement, there is no applicant stricto sensu. To be an applicant, you have to have an application, and that is a different way of seizing the court.
Certainly.
Thank you, Mr. President.
Please proceed.
The people of Behestoon rely on the Ozoonio River for their domestic needs and for their industries. Without this resource, the very lives and livelihoods of the people of Behestoon are threatened. Yet this river, this lifeline, has been all but destroyed by the insensitive and irresponsible contamination of the waters by Behestoon's upstream neighbour, Agistanus. The destruction of this natural resource has resulted from two major sources of pollution by Agistanus. Firstly, their agricultural activities, including the construction of the Nampshi Dam, and secondly, the toxic plume emanating from their mining operations. May I assume that the bench is familiar with the facts, or would Your Excellencies prefer that I outline the key facts relied upon by the applicant?
We are familiar with the basic facts, so please proceed.
Thank you, Mr. President. The government of Behestoon maintains that Agistanus is responsible for the injury it has suffered, and to this end makes 4 submissions. Firstly, that Agistanus' use of the Ozoonio River has violated Behestoon's right to reasonable and equitable utilisation of that river. Secondly, that Agistanus' response to the mining accident is inconsistent with environmental safeguards. Thirdly, that Agistanus has violated its obligation to prevent harmful transboundary pollution to the Ozoonio River. And fourthly, that Agistanus must therefore make reparation to Behestoon. I will be addressing the court today on the first 2 submissions, while my learned co-agent Ms. Gauntlet will be addressing the court on the 3rd and 4th. The essence of my first submission is that Agistanus' monopolisation of 33% of the Ozoonio River and pollution of the remainder is a breach of Behestoon's right to reasonable and equitable utilisation of that river. This principle of reasonable and equitable utilisation entitles each state sharing an international watercourse to a reasonable and equitable share in the beneficial uses of that watercourse.
What is the legal basis of this right that you claim?
It is a submission of the applicant that this right has been now accepted as customary international law and is binding on the parties in this case.
How has it become customary international law?
It is evidenced in numerous international documents, including the 1992 Rio Declaration on Environment and Development and the 1972 United Nations Declaration on the Human Environment.
How do these instruments fall within the category of Article 38 of the ICJ statute? Are they treaties? Or if you consider them as customs, then how do you prove to the court that they are indeed customs and they are a sufficient state practice as well as the opinion juries to support that?
They fall under the jurisdiction of this court, can be considered by the International Court of Justice under Article 38, paragraph 1b, where it states that the International Court of Justice may apply international custom as evidence of a general practice accepted as law.
What are the precedents for the meaning of this practice?
There are several examples where this principle has been used in state practice, and in particular I would draw the court's attention to the 1972 dispute between Argentina and Brazil. In that case, plans were made by both Brazil and Argentina to dam the Parana River. Brazil's upstream dam at Itaipu would adversely affect Argentina's dam at Corpus. However, in this case, both countries specifically recognised the right to equitable utilisation when they signed the Act of Asunción in 1972.
Yes. Judge Feller,
To follow on some of the previous questions, you are giving an example of 2 states located far away from your 2 states. Is your assumption that a norm of or a rule of customary international law is applicable erga omnes? Or would you have, for the purpose of applying a rule of customary international law to a specific situation, to prove that the states in question themselves have also agreed that this is a rule by which they are bound as custom?
It is a submission of the applicant that if a particular principle is supported by enough state practice and opinio juris as to become a principle of customary international law, then it is binding on all parties, regardless of their acquiescence to that particular principle.
But here you only cited one example between 2 states. Do you have another example to substantiate that this is indeed a custom that applies to everybody, all states?
Certainly, Your Excellency. I can draw the court's attention to comprehensive approaches designed to achieve equitable utilisation, which have been taken by states in relation to several international watercourses, including the Senegal Basin, the Niger Basin, the Gambia Basin, and the Chad Basin.
But of course, all of these examples you are giving are indeed systems for specific watercourses agreed to by treaty between the states concerned. whereas in your particular case, there is no treaty concerning the utilization of the water. So how could you make applicable, as a rule of general customary international law, erga omnes, to this particular situation, what in effect is a series of examples that have been dealt with by treaty, by agreement between the parties?
It is a submission of the applicant that these examples I have outlined are evidence that the principle is accepted as customary international law and as binding on states by the parties to these particular examples. They themselves constitute example of state practice, such as to create a rule of customary international law. The unifying theme of these documents and practices is the recognition of equal and correlative rights of the parties to the uses and benefits of international watercourses. The principle has been recently conveniently formulated in the International Law Commission's draft articles on the law of non-navigational uses of international watercourses. In particular, Article 5 of those articles states that watercourse states shall, in their respective territories, utilise an international watercourse in an equitable and reasonable manner.
Madam Agent, to what extent is the use of Behestoon's practice of the waste industry reasonable and equitable when you dump waste into the Ozoonio River yourself?
It is true, Your Excellency, that Behestoon is depositing some byproducts in the Ozoonio River. However, I would also point out to the Court that Behestoon is itself undertaking extensive waste recycling and recovery projects to deal with some of the waste that they are producing.
But then implicit in your response, Madam Agent, is that above and beyond what you've said, Agistanus has a special responsibility towards Behestoon, which Behestoon does not have in response to Agistanus, because Behestoon is the downstream riparian user. Is that not the case?
That is not the submission of the applicant. The submission of the applicant is that Agistanus's use of the Ozoonio River goes above and beyond what is considered reasonable and equitable, and that the use of the Ozoonio River by Behestoon is reasonable and equitable. In particular, I can outline some factors for the Court to apply in determining whether a use is reasonable and equitable.
Before you do that, Madam Agent, let me ask you a question about the mining accident that occurred.
Sir?
Previous to that, both Agistanus and Behestoon were using the waters of the Ozoonio River. Would you regard that state of affairs as a reasonable and equitable use of the waters?
It is not submitted. It is a submission of the applicant that the mining accident is a subject of other obligations. In particular, is a breach of Agistanus's obligation not to cause significant transboundary harm to Behestoon. And in that respect, if the reasonable and equitable utilisation principle were to be applied, it certainly could not be considered reasonable and equitable. The factors to determine whether a use of the river is reasonable and equitable were outlined by the International Law Commission in their draft articles, in particular in Article 6, paragraph 1.
I would like to probe you further on this question of sources here. It's very fundamental to the whole question of what is international environmental law, and does it have any binding effect or not. You are citing now a draft, a final draft, but it's still a draft from the International Law Commission, one that has been submitted to the General Assembly as a framework agreement, and one of which the Assembly has not been able to decide whether it should adopt it as a model, as a guideline, or as a convention. And you would like us as a court to consider that the elaboration of these principles in this draft are such that they represent existing law that we are able to apply to this particular case. Why do you give to a draft, even if it is from the main codifying body of the General Assembly, such a value in the absence of an expression by states of their agreement with the provisions of such a draft.
As a preliminary point, it must be said that the International Law Commission's draft articles are in themselves evidence of what the International Law Commission believes to be customary international law in this area. And perhaps in that respect, I can draw the Court's attention to a comment made by the Special Rapporteur, Sir Robert Rosenstock, of these particular articles. In relation to the principle of reasonable and equitable use, he said, "It is submitted that the right of each state to share equitably in the uses of the waters of an international watercourse system is indisputable and undisputed. It is a submission of the applicant that while these particular articles do not of themselves create binding obligations on the parties, they are further strong evidence that the principle is accepted as customary international law." The most important of the factors outlined by the International Law Commission in Article 6, Paragraph 1 are the social and economic needs of each state, the effects of the use of the waters on each state, and the availability of alternatives. In this case, Agistanus has reduced the flow of water to Behestoon by 33% and have polluted the remaining 67% with toxic levels of agricultural chemicals, including pesticides, herbicides, nitrates, and estrogen-based enzyme compounds.
Is there any rule that would determine the percentage beyond which the utilization would be unreasonable and unequitable? Why 33% is not reasonable? Why would it be 25, 50, 40? Is that also a rule of customary international law?
It is a submission of the applicant that it is not merely the reduction of flow of 33%, but its combination with the pollution of the remaining 67% of the Ozoonio River that has caused the harm suffered here and that has made this use of the Ozoonio River by Agistanus not reasonable or equitable.
What would be your answer if the respondent argued that this is their sovereign right to use their natural resources? Can you give us the court your opinion? How should the court deal with that question?
It is a submission of the applicant that there is no absolute sovereign right to use natural resources at international law, that any rights to use resources are limited by this principle of reasonable and equitable utilisation, and that in fact the respondent's use of the Ozoonio River is not reasonable or equitable.
This goes back again, the question of source of law. In light of Article 38, where would you place the legal basis of your argument? Under which sub-items that your legal argument falls?
The applicant's legal argument is that the principles are recognised as customary international law as can be applied by this court under Article 38, Paragraph 1b of the International Court of Justice Statute. As to the social and economic needs of each state, it is true that Beheston has received some benefits as a result of Agistanus' use of the Ozoonio River. However, Beheston's economic reliance on the Ozoonio is considerable. The watercourse provides Beheston with 90% of its water, used both domestically and industrially. As to the effects of the use on each state, Agistanus' use of the Ozoonio River has had devastating effects on Beheston's use.
If I may ask you a question regarding your characterization that Beheston relies to some extent on the benefits. Is it not in fact more than that? You have 2 water desalination plants at the Ozoonio Bay which provide you water. You've established a major freight handling and transfer point at the mouth of the Ozoonio River. You derive benefits from the dam that Agistanus has built. I would not call that some benefits. It's quite substantial, is it not?
Perhaps Your Excellency would describe the benefits as substantial. However, it is a submission of the applicant that even such substantial benefits are far outweighed by the devastating effects that these development projects have had on the Ozoonio River. In particular, I can draw the Court's attention to the loss of productivity in riparian agricultural lands in Behestoon, to the reduced river fishing stocks in the Ozoonio River, and to periods of extreme eutrophication in this river. is also true that
all of these environmental degradation to any particular act that Agistanus, or series of acts that Agistanus has engaged in.
it is a submission of the applicant that there is a direct causal link between the activities of Agistanus and the harm suffered in Behestoon. This particular submission will be dealt with in more detail by my learned co-agent. However, that is the essence of the applicant's submission. Perhaps I can move briefly to my second submission, that Agistanus's response to the mining accident is inconsistent with environmental safeguards it owes to Behestoon. In particular, Agistanus has breached its duty to notify of impending danger, to its duty to mitigate the effects of that danger, and its duty to cooperate with Behestoon. The duty to notify potentially affected states of imminent threat of serious harm has been recognised in this court as customary international law in the 1949 case of the Corfu Channel. In that case, the court based this obligation on general and well-recognised principles such as elementary considerations of humanity. The duty has since been reiterated in numerous international documents, including the 1992 Rio Declaration. On the facts before us in the compromis, Agistanus has clearly failed to notify Behestoon of imminent threat of serious harm. In particular, we are dealing with huge quantities of malodorous, highly mineralised and corrosive water. Your Excellencies, I see my time has expired. Might I be permitted to briefly conclude?
For your intervention, and I now invite your co-agent to take it.
Thank you, Your Excellency.
Mr. President, Your Excellencies, Behestoon is asking this court to order Agistanus to pay damages. Agistanus has polluted the Ozoonio River. As a result, Behestoon's environment has been spoiled, its economy has declined, and its people's lives have been endangered. It is this harm that gives rise to Behestoon's claim for damages. And in support of its claim, Behestoon makes two submissions. Firstly, that Agistanus has violated its obligation to prevent harmful transboundary pollution. And secondly, that Agistanus must therefore make reparation to Behestoon. Turning to the first of these submissions. In order for there to be a violation of international law, three conditions must be satisfied. Firstly, there must be a binding obligation and a failure to fulfill that obligation. Secondly, there must be a causal connection. And thirdly, the requisite standard of liability must have been met. Your Excellencies, it is proposed to deal with each of these conditions in turn. I will firstly identify the harm that Behestoon has suffered, and I will then establish the cause of that harm. Agistanus has failed to fulfill its obligation to prevent harmful transboundary pollution. And in this regard, I would refer the court to Article 10.1a of the Helsinki Rules on the uses of the waters of international rivers. And if Your Excellencies would like to follow this provision, it is cited at...
Yes. You have the floor, Judge Valencia.
Thank you. I would like you to distinguish as a factual matter the situation before the earthquake and after the earthquake. Does your argument cover the whole of the situation after the building of the dam and before the earthquake and after, or is limited only to the damage that has been caused after the earthquake?
No, Your Excellency, the applicant's submission has several components. I will discuss the harm that has arisen as a result of Behestoon's agricultural activities, and I will also discuss the harm that has arisen as a result of the mining accident.
Why did you not raise this complaint until such time as there was a damage arising from the earthquake, if there was a damage before arising out of agricultural activities? You
Yes,
seem to, on the contrary, to have as it were, accepted the situation and carried out your own utilization of the river without too much concern to this particular effect.
Could I take Your Excellency to the compromis? At line 159, it is stated that Agistanus had all but realised the full benefit of the installation by 1992. Now, sometime later, at line 189, Behestoon complained to Agistanus. The mining accident actually occurred in 1993. So there was, in fact, a very short period of time between the time when Agistanus was actually realising the full benefit of its developmental activities and the mining accident. And in fact, the reason it has taken Behestoon perhaps some time to complain and to bring this matter to the notice of the court is that Agistanus development did not occur suddenly. It occurred over a period of years. And in this regard, I would again refer the court to line 151 of the compromis.
Are you arguing that the development of Agistanus is in itself a cause of damage to Behestoon?
Yes, Your Excellency, you have asked me about the issue of causation, and in fact, the bench has already raised this issue, so I'd like to move to that part of our submission immediately. It is the applicant's submission that there is a direct and uninterrupted chain of causation between Agistanus' development activities and the harm suffered by Behestoon. And this will be discussed in regards to Agistanus' agricultural activities and also in regards to its mining activities. Your Excellencies, in regards to Agistanus' agricultural activities, the causal connection can be established or can be inferred from three main factors. Firstly, tests have revealed that Agistanus has polluted the Ozoonio River with its agricultural chemicals. The runoff water is also known to be saline. Secondly, it has been scientifically proven that salt and toxic degrees of agricultural chemicals cause precisely the effects which have been suffered by Behestoon. And thirdly, and most importantly, the period during which this harm has been evident corresponds precisely to the period during which Agistanus has been undertaking its development activities. Now,
is salinity in and of itself evidence of pollution?
Yes, Your Excellency, it is submitted that salt falls within the definition of pollution. I should firstly outline to the court the definition of pollution, and in this regard, I would refer the court to the International Law Commission draft articles on the law of non-navigational uses of international watercourses. Article 21.1 is a convenient formulation of the definition of pollution, which is a detrimental alteration in the composition or quality of the waters of an international watercourse which results directly or indirectly from human conduct.
Madam Agent, if you'll entertain the following hypothetical, assume Behestoon extracted more water out of the Ozoonio such that the brackish waters and the saline waters of Salonia Bay in fact started to run upstream, as it has been known to happen. Would you say that your client is guilty of pollution?
Your Excellency, it would not be guilty of pollution, but certainly salt can be regarded as falling. Well, the difference is that it must be the result of human conduct. So in Your Excellency's...
Humans live in Behestoon, Madam Agent.
Yes, Your Excellency, but the reason that the water would be coming into the river would be as a result of the tidal flow of the oceans. So in that regard, it would be a feature of nature and would not be a result of direct human conduct.
A feature of nature, or is also the result of human conduct?
Your Excellencies, in regards to Agistanus mining activities, the question is, what was the real cause of the harm suffered by Behestoon? Was it, in fact, the earthquake, or was it Agistanus' own conduct? It is the applicant's submission that the real cause of the harm suffered by Behestoon was Agistanus' own conduct both before and after the occurrence of the earthquake. In regards to Agistanus' conduct before the occurrence of the earthquake, 2 points can be made. Firstly, both dams and mines are known to significantly increase the risk of seismicity in the area. And in this regard, I would refer the court to a series of international conferences on mining-induced seismicity. For example, the 1983 London Symposium on Rock Bursts, Their Prediction and Control, and the 1984 proceedings of the first International Symposium on Rock Bursting and Seismicity in Mines. Now, the second point that Behestoon wishes to make is that it appears that Agistanus actually knew of the existence of the tar-like strata with the fluid circulating in it, because although it had been de-emphasized in the IRADB report, it nevertheless had been mentioned, and also Agistanus' own experts had drilled in the area. So we have a situation where Agistanus knowingly built a mine next to a tar-like strata in an area which was subject to increased risks of seismicity.
Excuse me, could I ask, were you not invited when the planning for the dam was underway to make your views known? Were you not invited to look at the scientific examination of the site? And in particular, I ask the question against the background that you are, in fact, benefiting from the hydroelectric power generated by the dam.
Yes, Your Excellency, it is true. However, Behestoon actually filed objections and reservations with regards to certain effects that the damming of the river might have on their domestic and industrial water usage, and this is stated quite clearly at line 111 of the compromis. It is also the case at line 189 of the compromis that the Prime Minister of Behestoon complained to the relevant officials in Agistanus and expressed concern as to the state of affairs that were developing in the Ozoonio River.
Yes?
If I can quickly go back to your first argument. If I understood correctly, your claim is that the use by Agistanus of the river for agricultural and mining purposes violated Agistanus' obligation to avoid transboundary harm. However, isn't this a sovereign right of Agistanus in terms of the pursuit of its development? I don't understand what your claim is whether the right of development of Agistanus is in contravention of its obligation to prevent transboundary harm, or whether Agistanus used the river in its developmental plan behind the threshold of reasonable use. What is your claim?
Your Excellency, it is not disputed that Agistanus has a right to sustainable development. However, that right is a qualified right. It is not absolute. And it is qualified by the transboundary principle that a country, a state, may not permit any activities under its jurisdictional control to cause harmful pollution in another state. And this, in fact, this dual concept is contained within Principle 21 of the Stockholm Declaration. So,
I would like to be clear here. Are you arguing that Agistanus was under a duty to behave, as it were, more reasonably towards Behestoon than it would have been towards its own population? Because I understand the dam is not built on the border between the two countries, but somewhere inside Agistanus. To follow your argument about the negligence almost of Agistanus in building a dam and in an area that was prone to earthquakes, obviously the effect of an earthquake would be as devastating on Agistanus' territory and population as it would be on Behestoon. And do you think that this argument can be made, that the transboundary harm principle is only concerned with the effect, of course, on the other state, irrespective of what the due diligence of a state towards its own territory and nationals should be?
Your Excellency, as I understand your question, it really leads to the consideration that there are two different systems of law at stake. One is a municipal system, which imposes certain obligations in regards to conduct which happens within that state. The other system of law is the international system of law, and that is the system of law that is before this court at the present time. Your Excellencies, I'd like to continue with the issue of causation. We have come to the point in this issue that Agistanus knowingly built a mine next to a tar-like strata in an area which was subject to increased risks of seismicity. Now, the problem is that Agistanus failed to take any reasonable precautions. It could, for example, have drained off the fluids before it commenced mining, or it could have erected containment dams. Both these procedures are well-accepted practices of underground mining. Also, the cost of...
Yes, Judge Eghbal.
If I may, Madam Agent, you said they could have done that. Is it your position that they were capable of doing it and didn't do it? And if they were capable of doing it, what has your client done to assist them in so doing?
Your Excellency, I would refer the court to the Society of Mining Engineers Mining and Engineering Handbook, in particular Chapter 21.1, which lays down certain standards or certain procedures which are undertaken in cases where mines are built in the vicinity of fluids. And it is submitted that if Agistanus has the capacity to undertake the construction of the mine, then surely it has the capacity to undertake the construction of the mine in a way that is consistent with generally accepted procedures of underground mining. Your Excellencies, it is also the case that the cost of undertaking these procedures would have been very small in comparison to the total cost of the development project, a total cost of approximately 10 billion United States dollars. And it is submitted that if Agistanus had followed these practices, the effect of the earthquake would have been very different. If Agistanus had erected containment dams, then the toxic fluids would have been prevented from reaching the Ozoonio River. But more importantly, if Agistanus had drained off the toxic fluids before it commenced mining, then quite simply, there would have been no toxic spill. So, Your Excellencies, it was not the earthquake that caused the harm suffered by Behestoon, rather it was Agistanus' own conduct. This is also the case.
Judge Lee.
Thank you. Follow the thought of Judge Eghbal. After the accident took place, what was the solution that you have proposed?
Your Excellency, it is submitted that Behestoon has in fact consistently tried to resolve the problem of the plume. Could I perhaps take you through some of the things in the compromise?
Can you answer my question first? I have a follow-up questions depending on your answer.
Your Excellency, I would like firstly to refer you to line 277 of the compromise, where it is stated that whilst negotiations were taking place, the appropriate time to build containment structures or otherwise block the flow of the plume had in fact now passed.
Am I right to understand that the solution that you have proposed to the respondent is that to open up the dam and flush out the pollutant into the sea? Is that correct?
Yes, Your Excellency, that's correct.
Now, my questions are as follows. Have you thought of any other measures? Why did you insist on opening up the dam to flush out the pollutants?
The reason, Your Excellency, is contained within a publication called Assessment and Remediation of Petroleum Contaminated Sites, which is published by Mr. Cole. And it is stated at page 53 of that publication that since polycyclic aromatic hydrocarbons are not degraded very well by microbial action...
What is the authority that the court should rely on? Should we listen to what Mr. Cole said?
Your Excellency, what I am attempting to place before the bench is the scientific reality of this toxic plume. Now, because those particles are actually absorbed by microbial and are not degraded very well by microbial action, it meant that, in fact, it was not possible to simply scoop off the...
Try to continue. So I understand the proposal you have is to dilution is the best solution to pollution.
Certainly.
Now, I like to be enlightened. Are you aware of any articles in the Law of the Sea Conventions which will make you liable or make you under legal obligation not to transfer from one area to another area the pollution?
Your Excellency, I regret I'm unable to specifically answer that question. However, I would like to emphasise that in regards to opening the valves of the dam, it is not a matter contained in the pleadings and it has not actually been brought before this court. It was a suggestion by Behestoon, but it is not in fact been emphasised nor followed up upon. So, Your Excellencies, if I could in fact move, because we are already in this area, of what Agistanus did after the earthquake. Now, it is acknowledged that Agistanus attempted to contain the toxic spill. Behestoon's complaint, however, focuses on what Agistanus did after this unsuccessful attempt. In simple terms, the government of Agistanus attempted to cover up the spill. It quashed all reports of the disaster in its national press, and it blatantly lied to Behestoon. What this meant was that no further action could be taken to contain the plume, and this enabled the toxic plume to continue its destructive journey downstream. So again, it was not the earthquake that caused the harm suffered by Behestoon. Rather, it was Agistanus' own failure to notify Behestoon and thus enable further preventative measures to be taken. Your Excellencies, I see that my time is running short, so I'd like to move briefly to my second submission, namely that Agistanus must make reparation to Behestoon. The leading case in this area is the Correl factory case, where at page 29, the court said that any breach of an engagement involves an obligation to make reparation. Now, Agistanus has breached its obligation to prevent harmful transboundary pollution. It is therefore under a duty to make reparation to Behestoon.
Yes, Judge Lee.
Thank you. Can you tell the court, to suggest to the court, how should the court assess the damage? What are the criteria that the court may use? And also tell us what are the legal basis for those criteria you're going to propose. Thank you.
Your Excellency, that does depend on the form of damage which one is discussing. Now, if it is economically accessible harm, then the position is relatively straightforward. And I'm assuming that what Your Excellency is really asking about are two areas of difficulty. The first area is the idea of future harm, and the second area is the idea of ecological harm. And so I'd like to address both of those issues. If I could take the court firstly to ecological harm, what we need to discuss are two things: measure and quantum. In regards to measure, the amount required is that to re-establish the position which would have existed if the wrong had not occurred. Now, this is the measure that has been established by the Correl factory case. And in regards to ecological injury, this involves two components. Firstly, the diminution in use value and intrinsic value, and secondly, the amount it would cost to restore or replace the equivalent of the damaged natural resource. Now, this measure was applied, in fact, in the Natural Resource Damage Assessment and Restoration Plan for the Exxon Valdez oil spill. It has also been incorporated in the Oil Pollution Act of the United States. Now, in regards to quantum, ecological injury has no market value per se. So what we need to be able to do is to quantify intrinsic value. And the technique that is used is that of contingent valuation. This particular technique was in fact upheld in an American case called Ohio and the Department of the Interior, and it was also applied in the Exxon Valdez damage assessment plans. So what Behestoon is saying to the bench is that there is a way the court can assess and analyze ecological harm.
Yes, Judge Lee.
Are you suggesting that the court should apply the principles contained in U.S. law to the present case, particularly taking into account that you are a developed country, whereas the other sides are developing countries, and the damage should be assessed on that basis?
Your Excellency, the reason I have cited those particular authorities is because the area of environmental law is a nascent area, and unfortunately, in international law, there are very few authorities. So what we need to be able to do is find a way that this court can resolve this problem before it. And if there are no authorities in international law, then the court can be assisted by the methodology that is applied in municipal law.
I thank you for your answer. Your time is out. I note that you have reserved 3 minutes for rebuttal.
May it please the court.
I now invite counsel for the respondent, Agistanus.
Mr. President, members of the Honourable Court, may it please the Court. I am Maria Luisa Bongo, agent for the government of Agistanus. My co-agent is José Luis Gascon. For this afternoon's proceedings, I would like to reserve 22 minutes for myself, 20 minutes for my co-counsel, and 3 minutes for Sir Rebuttal. If I may proceed, Your Excellencies.
You may proceed.
Thank you. Excellencies, the government of Agistanus comes before this court asking that first it should not find Agistanus liable for any of the alleged violations of international law. Our arguments will be divided among 5 principal arguments. First, the Augustinian government submits that because of the doctrine of estoppel, the government of Behestoon is precluded from seeking the relief that it does before this court. The second argument is that the government of Agistanus has not violated the norm of equitable and reasonable utilization in its use of the waters of the Ozoonio River. As our third argument, we shall also argue that Behestoon, or Agistanus, is entitled to sustainable development and has not violated this norm. My co-agent will argue that we have not violated the applicable environmental safeguards as alleged by Behestoon, and that lastly, because the proximate cause of the accident or the mining incident is an act of God, then under either fault or strict liability, the government of Agistanus cannot be held liable. If I may proceed to my first argument, Excellencies. Thank you. Excellencies, it is the contention of the government of Agistanus that upon the doctrine or the equitable doctrine of estoppel, the government of Behestoon is precluded from seeking the relief that it does. Under international law, where a state cannot come to court upon clean hands, it cannot therefore seek the relief that it does. In this case, Behestoon has clearly acquiesced in the acts of Agistanus. You will note, Excellencies, that initially Behestoon did make an objection to the bank and did file a reservation. It filed reservations and objections specifically to the alleged effects of the damming of the waters upon their domestic and industrial uses. In that case, their reservation and their objection was very specific. At that time, they already knew that the loan application was to be made applicable to the building of the dam and further developmental activities. These activities included the mining operations, the increased agricultural activity, and indeed the hydroelectric plant. Therefore, when it specifically filed its reservation and objection to the potential effect upon their own uses, it therefore, in fact, acquiesced in whatever developmental activities Agistanus had proposed to the bank. Excellencies, you will find that the doctrine of estoppel is accepted under international law and by this court in 2 principal cases. First, the case of the Grispadana. In the Grispadana case between Norway and Sweden, it was found by this court that when Norway failed to object to the building of the lighthouse upon a bank contested between both states, it was held that Norway was in fact precluded from further questioning the adoption or occupation of Sweden of that particular piece of land. Again, in the Temple of Preah Vihear case between Cambodia and Thailand, this court held that when Thailand failed to object to the making of the map, which showed that the situation or the location of the Temple of Preah Vihear was in fact in Cambodia, Thailand, was therefore precluded from further questioning the acts of Cambodia in claiming that the Temple of Preah Vihear was Cambodian territory. In these 2 instances, Excellencies, we can see that in fact the doctrine of estoppel is well accepted under international law.
Yes, Judge.
In point of fact, isn't the major claim of Beheston related to the mining, to the incident subsequent to the earthquake? So how could the estoppel affect this particular incident?
Excellencies, it is the contention of the government of Agistanus that although the principal claim was the resultant damage of the earthquake, you will note that again they say that the earthquake was not an act of God. They point out to the correlation between the building of the dam, the location of the mines, and the increased agricultural activities. If it in fact was foreseeable, then they too knew the consequences of building this dam so close to the mines. If they did know this and they brought this up before the bank, when they did not further object to the building of the dam and to the continued mining activity, they have in fact accepted the consequences and the potential dangers of this activity. You will note, Excellencies, that when they failed to further object and to submit further objections respecting the use of these waters, they in fact acquiesced and admitted that the potential viability of the mining activities and the dam and the agricultural activities was in fact acceptable to them. To proceed to my, excuse me. Yes, Excellency.
Agent, so if I understand your argument correctly, the only word missing from the objections Behestoon had filed previously is the word continuing. If they had put in the word continuing, they would have met your criteria, would they not?
Excellencies, yes. Under international law, there are three requisites for there to be a permanent or a valid objection. These are that it be firm, permanent, and immediate. You will see that in this case, when they did file the objection, it was in fact immediate. It was at that stage when the proposed project was brought not only before itself, but also before the bank. However, they failed in the two other requisites, that it be permanent and firm. You will note that not only did they acquiesce, they in fact ratified all acts of Agistanus by continuing to gain the benefits of this developmental activity.
If this court were to agree with your interpretation of the facts, would we not in fact hold ourselves hostage to the dictionary just because the word permanent was not in it? We should ignore the conduct of Behestoon subsequent to all the acts that Agistanus has undertaken.
Excellencies, with respect to the doctrine of estoppel, we are not saying that they are estopped from perhaps questioning the potential effects of this dam in regards to pollution. What we are saying, and we are not saying that you are hostage to the dictionary by, in fact, interpreting permanent, but even under international law and by this honorable bench, it has held in various cases, again I point to Grispadana, to the Temple of Priya Vihar, and to various other cases where this court has held that the objection must be permanent. Otherwise, in that instance, the state which does not object in a limited period of time or a given period of time, it is therefore precluded from further bringing objection to this court respecting that particular activity. If I may proceed, Excellencies.
Yes, Judge Bulci.
I'm sorry, just on another point of fact. Isn't it true that the Prime Minister of Behestoon complained? Isn't a complaint at the level of Prime Minister firm enough in political terms? And secondarily, if the facts, if I understood correctly the facts, didn't Behestoon request the building of containment dams by Agistanus so that possible spillovers from the mining activities be contained before they go into the Ozoonio River?
Excellencies, to answer that question, there are 2 points of time that must be taken into consideration here. First is that they made the preliminary testing of the waters before the mining incident. So therefore, we have the testing of the waters before the incident occurred and then the testing of the waters after. If you are referring to the incident before, or excuse me, to the testing of the waters before the incident, the Prime Minister noted that there was increased level of toxins in the waters, presumably because of the activities of Agistanus respecting agriculture. They point to the fact that the varieties are the organic toxins in the water pointed to the very varieties allegedly used by Agistanus. Excellencies, when you use fertilizers, whatever they may be, they contain inevitably the same organic matter. There does not therefore exist the alleged direct causal connection between our agricultural activities and the potential damage, excuse me, the agricultural toxins in the river. You will note, Excellencies, that the Corfu Channel case, this court, although it allowed using circumstantial evidence, it said that this circumstantial evidence must consist of a series of facts leading to a single conclusion. There are two conclusions possible here. The first conclusion is because Behestoon is highly industrialized, because it has berthing facilities, because it has a petroleum refinery, that much of the pollution of the Ozoonio in their territory is in fact their own pollution and not in any way attributable to Agistanus. The second conclusion is that possibly the increased agricultural activity of Agistanus has in fact contributed to the pollution in the river. But Excellencies, it is Agistanus' contention that there is pollution, and if this pollution is caused by Agistanus, it was well within tolerable levels. The fact that it became increasingly dangerous was because the pollution in the Ozoonio, in the part that existed in Behestoon, was already to such a grave extent that any amount of increase of pollution would have in fact been dangerous. So in that sense, Excellencies, again, we point to the series of events that clearly shows to this court that it is not solely Agistanus which is responsible for the pollution in the Ozoonio River. If I may proceed, Excellencies.
You may proceed.
Thank you. Excellencies, with respect to our second point, Behestoon contends that Agistanus has not made use of the waters of the Ozoonio in an equitable and reasonable manner. Again, it is our contention that we have. They have again alluded to the 1966 Helsinki Rules of International Rivers and also the draft convention by the ILC. You will note that both these draft articles and the 1966 Helsinki Rules essentially list the same factors. These factors are non-exhaustive and they must be applied in particular geographical and hydrologic conditions of a shared river. In this case...
Yes, Judge Lee.
Yes, Excellency.
From your argument, I presume you accept the applicant's argument that indeed there is international law substantive principles and norms regarding equitable use, reasonable use amount. So you do not question that there is the legal basis for that. You proceed to argue that you have not violated those principles. Do I understand you correctly?
Certainly, Excellency. As a nation within a community of nations, we recognize that there is a duty to protect the environment. And because we recognize this, Principle 21 of the Stockholm Convention or Declaration already states the basic principle of sicutere tua ut alienum non liedis. This is a Roman law concept which has been around since time immemorial. And because equitable and reasonable utilization is based upon that doctrine, then as a nation, principally regarding protecting environment, we recognize that we too, as a co-riparian state sharing an international river, we have a duty to protect that resource.
Do I understand you, you have no question to accept that these are principles of customary international law?
Yes, Excellencies, they are. Again, we point out to various cases using this principle, such as Lek Lanu, which said that there is a community interest which must be protected in using this particular river. So therefore, we do accept these criteria or these factors in determining whether or not a particular use is reasonable and equitable.
How then you assess, you come to the conclusion that these are customary international law? Can you help the court to establish that basis?
Excellencies, we contend that it is customary international law upon Excellencies, customary international is evidenced by state practice and opinio juris. In this case, there is consistent state practice where various states have applied the equitable and reasonable doctrine in coming to an agreement on how to harness a shared international river. This has been held in the Nile River Treaty case, in various treaties between Latin American countries sharing international rivers, and also on the Asian continent. You will note, Excellencies, that although it has not come to full fruition, in the Mekong Delta at the moment, countries in that region have come together to discuss how to particularly harness the Mekong Delta. They have, in fact, relied upon the factors as listed by the ILC and the 1966 Helsinki Rules to come to a determination how these various nations along the Mekong can utilize that river. So, Excellencies, the fact that these nations have agreed to use these principles clearly shows that they feel and they know that it is a binding obligation. And when states recognize that it is binding upon them and they apply them, then that constitutes your opinio juris.
May I follow up on the question of damage limitation? The argument that you didn't take action in order to prevent damage to occur. You have argued eloquently about the principles that Judge Lee asked you about. What about damage limitation? What about your duties to take action when you realized that there was a threat to the environment because of the plume that was wandering down the river?
Excellencies, I take it that you are referring first to the duty of emergency notification. In this case, we recognize that in such a situation, there may be a duty.
Just to complement your question,
Please,
if I may, I was going to raise specifically this duty of notification. In addition to answering this specific question, would you also say that these are duties under customary international law?
Excellencies, it is the contention of the government of Agistanus that there does exist a duty to give emergency notification of situations in a territory, or our territory, which is likely to have sudden transboundary effects. This principle, or this notion of giving sudden emergency notification, was again enunciated in Principle 18 of the Rio Declaration. But as you will note, in Principle 18, it only says that states are mandated to give emergency notifications of activities or occurrences in their territory that are likely to give sudden harmful effects. It is our contention that this duty did not arise here, because what happened was not, in fact, sudden. The incident, the earthquake, may have been sudden in the territory of Agistanus, but certainly its transboundary effects were not sudden with respect to Behestoon. You will note that the facts are clear. On August 13, a temblor occurred. When it occurred, it was subterranean. The immediate effects of that temblor were underground. There was a tar-like strata revealed, and the corrosive liquid filled the mines within 36 hours. During that 36 hours, much of the corrosive liquid was still underground. Therefore, nobody knew of its existence except perhaps our miners. At that point, the immediacy was only with respect to the environment of Agistanus. Now, when this corrosive liquid, mixing with the tar, began to ooze out of the mountain surface along the streams of the river and then mixed with the waters of the Ozoonio, then potentially there might have been a danger. Recognizing this potential danger, Agistanus, on the part of its due diligence duty, undertook to contain the spill. Excellencies, we did not fail in our obligation to mitigate potential harm. What we failed in was the fact that we did not have the appropriate equipment and technology. I certainly don't think that a developing state should be penalized simply because it has not achieved a level of development sufficient to meet this particular obligation. You will note, Excellencies, that again under the draft Articles of Responsibility for Injurious Consequences for Non-Prohibited Acts, in the commentaries on this, Gunther Handel himself said that a developing nation may pass on liability to the exporting state or institution which has the technology to mitigate this harm. This, we believe, is in conjunction with the environmental impact assessment requirement that is allegedly required of us. In this case, it was clearly the bank which possessed this technology, and it was a due diligence.
Could I just follow up before I give the floor to Judge Lee?
Yes, Excellency.
You argue that Agistanus is a developing country and that it should not be held liable because they don't have the technology. Isn't that a fact that Behestoon was inquiring about what has happened, and that maybe Behestoon was in a position to assist? What steps did you take to ascertain that a danger that obviously you know about was contained, and that you tried to limit the effects of something that had occurred, irrespective of whether it was due to the earthquake or something else?
Excellencies, at that point, perhaps realizing the danger, we had already contacted the bank. And in this area, the bank was already in our territory, monitoring our activities. You will note that in the compromis it is stated that the bank, at that time, if any of Agistanus failed to comply with any of the requisites of the loan application, control would revert to the bank. It therefore implies that all during this time we were undertaking this developmental activity, the bank was still present in our territory. And recognizing the expertise of the bank in this particular aspect of developmental activities, we had in fact exercised due diligence in relying upon the expertise and technology of the bank. Now,
does this mean that you would hold the bank responsible for what had happened?
Excellencies, the government of Agistanus, having benefited from the relationship between us and the bank, we ourselves would not hold the bank liable for this. But if Behestoon chooses to find or seek liability elsewhere or to attach liability elsewhere,
a legal basis for such a responsibility?
Excellencies, we believe that there would be. The bank, as our contention is an international organization. Because it is an international organization, it can therefore be made or brought before this court to answer for its own violative acts. This, in fact, was recognized by this honorable bench in the reparations for injuries case, where the United Nations, as an international organization, was allowed to come before the bench to seek relief on behalf of Count excuse me, I apparently forgot his name, that they did come before this court to seek reparations on his behalf. So in that...
I think Judge Lee had asked for the floor first. Judge Lee.
Thank you, Mr. President. I intended to ask the question exactly along the lines you asked. Now that you have mentioned the bank's responsibility, I'd like to follow up on that. In your view, do you think the court has the competence, following what you have just submitted, that the court could deal with the question of responsibility of the bank? In such event, how should the court hold the bank responsible, the members of the bank or the bank itself? Could you elaborate on that?
Certainly, Excellencies. Excellencies, we believe that the bank itself should be held liable, not only its particular officers. But in this case, since it is a liability of an international organization, then an action may be brought before another state to bring that bank within the confines of international law before this court. However, if there does not exist precedent, or in fact, international law to bring the bank before this court, then certainly because Behestoon and Agistanus are members of the same regional bank, there are presumably procedures within the bank structures that will allow Behestoon as a member country to bring action against the bank officials. So in that case, there does exist viable alternatives for Behestoon to seek to claim or attach liability upon the bank.
Your submission is that the bank has the competence in the present case to deal with the bank's responsibility. The court has the competence to deal with the bank's responsibility in the present case. Am I correct?
Excellency, the court may issue an advisory opinion respecting what they think is international law respecting liability of international organizations. But again, I must admit that there does not exist currently a case where a institution such as a bank of regional character or perhaps even the World Bank has been brought before this court. So in that case, perhaps the court can go into new ground and enunciate new principles of law.
Judge Valencia-Ospina.
Yes, Excellencies.
Most of the ground has been covered, Mr. President, only to point out that under the statute of the present court, of course, international organizations do not have a standing to appear either as applicants or as respondents, although their eventual liability as subjects of international law with juridical international personality is independent of whether that liability is to be determined by this court or not. I think I'll stay there.
Thank you. Judge Burci.
I would like to clarify one point concerning the duty of notification. Do I understand correctly that your argument is that Agistanus did not have a duty to notify Beheston of the toxic plume going down the river because there was not the requirement of suddenness or damage? And you argue as a legal basis for this requirement of suddenness only the Rio Declaration. Is there any particular authority to indicate that this adjective, sudden, is actually a requirement under general international law? And how do you interpret the requirement of suddenness? Isn't it rather sudden as opposite to continuous, like the pollution deriving from activities protracted in time, like agriculture? So what is the authority for that?
If I may answer that question.
You may answer the question, of course.
Excellencies, it is our contention that the suddenness aspect of this duty was discussed by the ILC commissioners. So in that sense, there is legal basis for saying that the suddenness requirement is recognized principally with emergency situations. This was also recognized in the Corfu Channel case, where in that particular instance, because of the existence of the mines and this knowledge, or the Albanian knowledge that there was the existence of the mines, immediately there was that suddenness. However, if we are saying that it is not only our duty of giving notification, is not only limited to the suddenness aspect. It is our contention, Excellencies, that if we had been afforded the opportunity to give notification to Beheston, we would in fact have. But what happened was they illegally intruded into our territory, gained evidence by themselves in violation of our territorial sovereignty and integrity, and in that sense, there was not any need to give them emergency notification. They knew.
I thank you for your answer. I'm afraid that your time is out, and I invite your co-counsel to take it.
Thank you very much, Your Excellencies, if I may.
Mr. President, Excellencies, good afternoon. May it please the court, I am Jose Luis Gascon, co-agent for Agistanus Respondent in this case. My co-counsel has already raised arguments dealing with the contentions of Behestoon as regards their claim that we have violated the duty of notification in emergency situations. She has also raised other arguments regarding why we believe that Behestoon cannot come before this court to seek relief because it is stopped as it has acquiesced in our development activities. Your Excellencies, I shall proceed to address their other contentions. They claim that we have not conformed with the principle of equitable and reasonable utilization of a shared resource. I shall then proceed to discuss the other so-called environmental safeguards that they claim we owe to Behestoon. And finally, I shall argue that Agistanus cannot be made liable for the damage suffered by Behestoon. If there are no questions regarding my outline, Your Excellencies.
You may proceed.
Thank you, Your Excellencies. Your Excellencies, my co-counsel has already admitted that we, as a co-reparent state to the River Ozoonio, acknowledge that because there is a community of interest regarding an international watercourse, that there are standards by which a particular use is determined to be equitable and reasonable. She had wanted to proceed to discussing the factors, but because this honorable court sought to seek her assistance regarding other matters, she was unable to do so, and I shall proceed to discuss these factors before you today. Your Excellencies, both parties admit that there are existing factors, and I would like to present to this court that there are 4 relevant factors regarding this. First, the dependence of the states regarding the particular shared resource. Your Excellencies, in this particular case, Agistanus, a developing country, is a landlocked state found in the upper mountains of the Gorgon Plateau. We are dependent solely on the waters of the River Ozoonio. Behestoon, on the other hand, is a coastal state. Certainly, they share the river with us and have a right to the beneficial uses of that river. But, Your Excellencies, surely our initiative of undertaking a development activity of damming the river to be able to extract sufficient quantities for our own domestic, agricultural, and manufacturing uses should be considered. Your Excellencies, second factor to consider is the economic and social benefits and dependencies of the states which share that river. Your Excellencies, Behestoon is a developed society. Yes, Your Excellency.
The International Court of Justice is a court of law. So far you have mentioned, it seems to me, they are not legal principles. I may be completely wrong. Could you tell me why the court should take into account these, what one may consider as the question of equity rather than legal principles?
Your Excellency, these factors form part of the legal principle of equitable and reasonable utilization. Certainly, the concept of equitable and reasonable utilization may be akin to the idea of equity. And this court is mandated under Article 38 when the parties so agree to apply the principles of equity. In this case, Your Excellency...
that agreement in this present case?
Your Excellencies, perhaps there is no written submission that we ask this court to decide this case with regards to ex aequo et bono, but Your Excellencies, both parties have now come before this court and asked this court to consider whether or not our uses are equitable and reasonable according to the principle of equitable and reasonable utilization. Certainly, Your Excellencies, in this particular instance, we have sought the assistance of this court to determine whether or not our uses are in violation of this equitable principle. If I may proceed, Your Excellencies.
You may.
Thank you, Your Excellencies. I was discussing before this court the factor of economic and social needs. Behestoon, Your Excellencies, is already a developed country. We, on the other hand, as a developing country, require the necessity of such a project in order by which we could develop as a society. Yes, sir.
Mr. Agent, are you in fact not equating the word development with the word industrialization? And if you're not, would you give me a definition of what development means?
Thank you, Your Excellency. Your Excellencies, industrialization is not equivalent to development. Industrialization may be only one aspect of the concept of development, because certainly development cannot be understood only in pure monetary terms. Your Excellencies, in fact, as regards activities related to the environment, the Brundtland Commission, or the World Commission on Environment and Development, has undertaken to clarify the standard of development that states should undertake in developing their resources. And this is the standard of sustainable development. This standard of sustainable development, as enunciated by the Brundtland Commission, Your Excellencies, involves the rights of states to undertake activities for economic growth of their societies to benefit the needs of their population without sacrificing the needs of future generations. The principle of intergenerational equity is included in this idea. So certainly, Your Excellencies, industrialization may be a program undertaken by a state, but it is not the only thing to consider when we speak of development. If I may proceed, Your Excellencies?
I may have one additional question.
Please, yes.
If I follow your argument, then in fact, development contains a whole host of other factors. Do you know of any case, either before this court or any other court, that has been adjudicated in which the holding has been to support your proposition?
Your Excellencies, I am not aware of a case before this court, but I am aware of a case in a municipal setting, if I may. Your Excellencies, in the country of the Philippines, there is a case that was filed regarding intergenerational equity. And this is the case of Oposa versus Pactoran. In that case, Your Excellency, children filed a case against the Department of Environment and Natural Resources to seek its assistance to prescribe certain owners of logging concessions to prevent them from continuing to log the forests. And Your Excellencies, the Supreme Court in that ruling, in that case, ruled that the right to a clean and healthful environment should be considered in undertaking or considering the rights and obligations of parties to any case. And so the rights of children to come before the court to seek assistance as regards their rights to a healthful environment was considered in that case. But Your Excellencies, this court does not take notice of such decisions of municipal jurisdictions. But nonetheless, Your Excellencies, under Article 38 of the statutes of this court, in certain instances, it may seek references to judicial decisions of municipal tribunals. It may also seek assistance from highly qualified publicists. And because the environment, Your Excellencies, is a new field, a growing field, and only now are obligations being clarified both in terms of treaty and custom, certainly this court may consider what is happening in other countries. Thank you, Your Excellencies. May I proceed? Thank you, Your Excellencies. I have already shown two factors. I shall proceed to the third factor. The third factor, Your Excellency, is efficiency of the use. Your Excellencies, we submit that the choice or decision of Agistanus to undertake a development activity such as this is efficient under the circumstances. Your Excellencies, prior to the building of the dam, it was only Behestoon that had beneficial uses essentially from this river. They had industries and domestic uses of this river. We had very little use for the river other than our domestic and water needs. But when we constructed the dam, we were able to extract its resources, first to utilize the water to irrigate land, 500,000 hectares of land which were previously semi-arid. Now we are able to produce enough food for our people and are in fact exporting food to other countries. Your Excellencies, we have also used the resources of the water to extract a rare earth mineral which is strategic to the world economy. Your Excellencies, considering that we have utilized this river to harness such a rare earth resource which would be useful to future generations is something that this court should consider. And finally, Your Excellencies, the hydroelectric power plant that we have constructed because of this dam has produced electricity to meet our needs, to meet the needs of other countries. And in this particular case, Your Excellencies, more importantly, Behestoon itself has bought electricity from Agistanus at favorable rates. At this point, in fact, we are providing them with 20% of their domestic needs. So, Your Excellencies, as you can see, we have, in fact, undertaken an activity which is efficient under the circumstances. If there are no questions, Your Excellencies, I will proceed to my last factor.
Judge Valencia-Ospina has a question.
How will you address the contention of the other party that it is precisely this development of your country, the way it has come about, that is at the root of the problems that they are experiencing now? We all agree all you have done is well and good, but it has been at the expense because of what the other party claims has been the lack of due diligence at the expense of their own uses. How will you address this contention of the other side?
Your Excellencies, we submit that we have in fact undertaken due diligence in our utilization of the resource. The utilization of the resource have benefited our country and theirs as well. In fact, the 33% diminution of the water as a result of the reservoir from that dam did not result in any obstruction of their current uses. Your Excellencies, they continue to undertake industrial activities. Their water needs continue to be met. We did not in any way, in due diligence and in good faith, violate their rights to the beneficial use of the river. Your Excellencies, as regards pollution, certainly when there is utilization of a resource, pollution would arise. And we submit that we have, because of our agricultural activities, caused some pollution. But Your Excellencies, pollution per se is not actionable. The pollution that would be sufficient for an action before this court should be one which is substantial in character, a pollution that would cause substantial injury. But Your Excellencies, Behestoon has not proven that there has in fact been substantial injury in this case. If you at all, Your Excellencies, the level of pollution that we have contributed to the river is de minimis. In fact, Your Excellencies, it is Behestoon that continues to dump their treated and untreated industrial waste directly into the river. So, Your Excellencies, the only difference is that we are upstream, and so we do not suffer the damage or injury from the pollution that they dump into the river. But Your Excellencies, they are signatories to the UN Convention on the Law of the Sea. And as a coastal state, they are bound to ensure that they protect or prevent pollution to the marine environment from land-based sources. Your Excellencies, in this particular case, we have shown to this court that we have not caused substantial injury to Behestoon, and in fact, perhaps, Behestoon, by its own polluting acts, has caused substantial injury to the community of nations as they are affecting the res communis in this case.
Yes, Judge Purci.
A state party or the Law of the Sea Convention?
No, Your Excellency. My country is not a state party to the UN Convention on the Law of the Seas.
You have no obligation to prevent harmful pollution to the sea and to other coastal states?
Even though we are not parties to the convention, we submit that there are certain aspects of the UN Convention on the Law of the Sea which are declaratory of customary norms of international law. In this day and age where we realize that the earth is a finite resource and the oceans provide the hope and future for many peoples, all states, whether they are coastal states or states that are landlocked, have a common obligation to protect this. But in this case, Your Excellencies, they have not shown what activities we had undertaken which has caused pollution to them.
Judge Valencia-Ospina.
Thank you. I don't remember reading in the agreed facts any reference to any party being a party to this case, being a party to the Law of the Sea Convention, and I take it is the Montego Bay Convention. There are also the Geneva Conventions. This is not clear. But I notice when your co-agent argue also a tendency to introduce new facts that of course would strengthen your own argument. I don't think that is necessary. You could argue independently of these additional facts, obviously take by surprise the other party because they have not been agreed. Could you make the same argument on the law of the sea without this fact that was not in the agreed set of facts?
Your Excellencies, I would seek the indulgence of the court to consider that, in fact, there are clarifications to the compromis, and a specific question was made in that compromis as regards to which states in this controversy are parties to the UN Convention on the Law of the Sea. And it is clearly stated therein that Agistanus is not a party, but Behestoon is.
Sorry, I have not noticed. No.
But, Your Excellencies, if I may address your other concern regarding references to facts, Your Excellencies, the provisions of the compromis refer to certain facts indeed, but the facts in themselves are unclear, and we are coming before this court, in fact, to clarify the facts with regards to this case. They claim that we lie, but we did not lie, Your Excellencies. They claim that we are in bad faith because we quashed information regarding the spill in our national press. But, Your Excellencies, we submit to this court that it should consider the doctrine that all acts should be presumed to be legitimately done until the contrary is proved. With regards to quashing information in our national press, you must understand that we had just suffered an earthquake. 36 hours thereafter, a spill had occurred, and we did not wish to cause undue, unnecessary panic among our population so that we could deal with the situation beforehand. In fact, Your Excellency, the quashing of the information in our papers were made long before, 2 days before, they had made initial inquiries regarding that. So, Your Excellencies, in this particular case, while indeed there has been damage caused to Behestoon, none of the damage can be attributed to the acts or omissions of Agistanus. Your Excellencies, they wish to assert that we are liable. And they say that because there is damage, there should be liability on the part of the source state. But, Your Excellencies, this doctrine or contention is based on the standard of strict liability, that when there is damage, someone has to pay for the harm caused. But, Your Excellencies, strict liability is not the regular standard used by this court regarding environmental harm. In fact, Your Excellencies, strict liability continues to be discussed as it is being discussed by the International Law Commission regarding international liability arising from injurious consequences from acts not prohibited by international law. And, Your Excellencies, strict liability is applied in only 2 instances: when there is a treaty between the parties that strict liability should apply, and second, when there is ultra-hazardous activities being undertaken. Certainly, building a dam, constructing mines, and agricultural activities cannot be considered ultra-hazardous. Your Excellencies, as regard fault liability, they say we are at fault, but for fault to occur, there should be a breach of an international obligation which is attributable to the state. In this case, Your Excellencies, we have shown that there is no breach. We have complied with our international obligations as regards the use and as regards environmental safeguards, so there can be no breach. And this, since there is no breach, there is no fault. When there is no fault, reparations cannot arise.
Thank you. Throughout your argument, I get this impression that you're not disputing on the basic principles, but what underlying your argument is that you are a developing countries. There is a limited resources and limited capability to deal with problems of this kind. And therefore, in the actual implementation, application of these principles, this account should be taking into account these factors. I wonder if you could help the court. Why should the court, since the court applies the legal principles in this case, why should the court give a more favorable interpretation of these principles to a developing countries and not to apply the criteria as they are equally to both countries? Thank you.
Your Excellencies, if I may direct this court to considering the Rio Declaration in this instance. Although the Rio Declaration is certainly a non-legally binding instrument, because it has been, the Rio Conference on Environment and Development has been participated by a tremendous, may I finish my?
You may
Yes.
answer the question.
Thank
Yes,
you. By a tremendous number of countries. In that document, Your Excellencies, there are two principles found in Principles 6 and 7 regarding, first, the obligation of states to assist developing countries regarding developing their resources, and second, regarding the concept or principle of common but differentiated responsibility of states, realizing that developed states have in fact been the most, the countries which have contributed most to pollution, they have a greater responsibility to prevent pollution.
Sorry, to follow up.
You may, yes.
This is precisely the point. Because it's not a legal instrument, and therefore states, it was adopted unanimously or has the general support. But would you think that the situation may be very different if they were adopted, or it were adopted as a legal instrument? States would probably object to those principles.
Possibly, Your Excellency, if in fact it would provide for conventional obligations, some states would perhaps not have manifested as much support as they did. But nonetheless, Your Excellencies, because of the growing concern for the environment, reference should be made to the notion that in fact soft law in the environmental law contributes greatly to the development of obligations. And in this case, Your Excellencies, we can consider Rio Declaration, although hortatory in character, contributes to the development of obligations if they reflect customary norms.
Thank you. I thank the agent for Agistanus.
Thank you, Your Excellencies.
And we proceed directly to the rebuttals? Yes. Well, we will proceed now directly to the rebuttals. Both parties have reserved 3 minutes for those. Madam Agent, please proceed.
Mr. President, Your Excellencies, in response to the submissions of the respondent, the applicant makes itself 3 submissions. In particular, in regard to the respondent's submissions on, firstly, the doctrine of estoppel, secondly, the duty to notify, and thirdly, the Interregional Agricultural Development Bank. Firstly, the respondent has submitted that the applicant was barred from claiming against them because they acquiesced to Agistanus' use of the Ozoonio River. In this particular respect, I would draw the Court's attention to the consistent objections of Behestoon to the development of the Ozoonio River in the manner undertaken by Agistanus. In particular, at lines 111 to 113, the compromise states that the IRADB granted Agistanus' application in 1980 over objections and reservations filed by Behestoon with regard to certain effects the damming of the river might have on their domestic and industrial water usage. I would also draw the Court's attention to line 189 to 191, where the compromise states, and this particular fact comes some 5 years after the operation of the Namche Dam has begun and the agricultural practice has begun. The compromise states that the Prime Minister of Behestoon complained to the relevant officials in Agistanus and expressed concern as to the state of affairs which appeared to be developing in Behestoon as a result of Agistanus' use of the river. This relates to the agricultural practices of Agistanus. It is clear that Behestoon has not acquiesced to Agistanus allowing 18 million litres of toxic and corrosive substances to enter their territory. As I'll again refer the Court to the compromise at line 245, where the compromise states that objections were made by Behestoon over the introduction of these chemicals into the river and concerns were raised to Agistanus. As to the respondents' submissions on the World Bank and its member institution, the IRADB, in particular, the respondent submitted that the applicant should pursue the IRADB for compensation for the results of the mining accident. In this respect, and as Your Excellency noted, under Article 34, Paragraph 1 of the International Court of Justice Statute, it states that only states may be parties in cases before this court. It further states in the Article of Agreement of the World Bank, of which the IRADB is a member institution, at Article 7, Section 3, that no actions shall, however, be brought by members or persons acting for or deriving claims from members. I would also address the respondents' submissions on their duty to notify arising in response to the mining accident. The respondents submitted that this only arose if the transboundary harm was sudden. In this respect, I would again draw the Court's attention to the compromis, where it states at line 242 that 2 days later, however, the Ministry of Environment in Behestoon noted the sudden occurrence of low-level and fast-increasing unidentified toxic substances at one of its sampling sites along the Ozoonio. May it please the Court.
May I ask a question, please?
Yes, Judge Lee.
Thank you. You have asked the court to decide on 3 questions. Basically, the question of rights, and then if the rights can be established, and then you'll be compensated. Now, the question remains that the pollutants are still there, the activities continues. What you ask the court to do is determine the compensation. According to your colleague's submission, include all future uses and so on. Does the court understand, in fact, you will let the situation to continue and you will be satisfied just with the compensation? You have not asked the court to have any interim measures to deal with the real problem, or are you negotiating with the respondent on some kind of arrangement to deal with the real problem? I realize this question really outside our compromise, but I think it's important for the court and also from the point of view of settlement of dispute to addressing the root of the problem rather than the consequence of the problem. Thank you.
Your Excellency, it is the unfortunate situation that the toxic plume is now still within the territory of Behestoon. The reason that interim measures have not been requested by Behestoon is that, unfortunately, such interim measures would be ineffective. As the compromise states, the appropriate time for containment structures has now passed, and as scientific evidence can show, polycyclic aromatic hydrocarbons are not easily biodegradable and cannot easily be cleaned out of the Ozoonio River. Unfortunately, the only way these toxic substances will be diluted or released from the river is by the opening of the valves of the Namche Dam. Given that this is not within the pleadings of Behestoon and is not specifically requested that this court order Agistanus to open the valves of the Namche Dam, Behestoon rests their claim for compensation for the consequences of this harm.
Thank you very much. I now invite the agent for Agistanus.
Mr. President, members of the Honourable Court, if I may proceed. Upon Sir rebuttal, Your Excellencies, it is the contention of Agistanus to answer the 3 points raised by the government of Behestoon. With respect to estoppel, it contends that its later 6-year opposition to the presence of the toxic substances in the river amounts to a continuing, permanent, and immediate objection. You will note, Excellencies, that in the facts, it is quite clear that the initial objection was made in the late 1970s when the proposed project was made. Thereafter, there existed no form of objections on the part of Behestoon. 6 years later, after the operations of the dam, which was precisely 6 years after 1986 upon completion, that was the only time that they objected again, precisely because they allegedly detected increased levels of toxins in the river. From the period of 1986 to 6 years later, 1992, there was no objection. What did Behestoon do? Behestoon purchased our electricity generated by the very dam to which they are objecting to. Not only did they do that, but because of the increased traffic on the river, because of our developmental activities, they built entreports, containment units, and new port facilities. What does this indicate? It indicates that, in fact, Behestoon has benefited from the beneficial uses generated by Agistanus. It, in fact, quite clearly shows that both states, on the equitable and reasonable doctrine basis, have in fact benefited from the reasonable use of the river. In that sense, Excellencies, it cannot say that it has firmly objected to the actions of Agistanus. There is a lull of 6 years from the continued operation of the dam before they even made an initial objection again.
Yes. You have the floor, Judge Eghbal.
Thank you, Mr. President. Madam Agent, you make an eloquent case for your cause, but is it not astounding that apparently neither Agistanus nor Behestoon have taken any due diligence care to the Ozoonio River in their strive for development and, as your co-agent has maintained, sustainable development? Can you provide this court with a useful definition of what sustainable development might mean?
Excellencies, under the Brundtland Report, sustainable development is defined as the capability to meet the present needs without jeopardizing meeting future needs. It has two aspects, preserving the resource and secondly, improving the quality of life. We contend that Agistanus has in fact met these two requisites. You will note that because of the single activity of building the dam, we have in fact harnessed the arid highlands of our region. Because we did this, we have increased agricultural food production, not only for our people, but the people of the region as well. That shows that we have in fact raised the standards of living for our people. And as mandated under the UN Charter's preamble, this court, or the United Nations, shall undertake all measures to promote social progress and better life in accordance with larger freedoms. It therefore shows that Agistanus is in fact conformed to the duty of sustainable development. Now, again, Excellencies, with respect to the IRAD Bank as their last submission, we contend that the IRAD Bank is an international organization with limited personality. Where does it then get its limited, if I may just finish that sentence, Excellencies? Yes. This limited international personality derives from the personality granted it by its member states, because Behestoon, Agistanus, and the 6 other members of the region have recognized the personality of the bank. It therefore does exist as a separate institution, apart not only from the World Bank, but apart from the individual governments which have granted it international personality. Thank you and good afternoon, Your Excellencies.
Please rise. Is adjourned for deliberations. Please remain at your seats during the deliberations.
Be seated. Before I will deliver our judgment, I should like to ascertain the names of the agents appearing on behalf of the applicant and the respondent. And if I understand it correctly, the agent for the applicant, the first agent was Alexandra Counsel. And the second agent is Fiona Gauntlet. The agents for the respondent is Maria Luisa Bungo. And the co-agent, Jose Luis Gascon. Thank you. Before I deliver our assessment, I should like to make a few general remarks. I'm sure that just as the 5 judges, the audience is impressed by the skill and the competence that agents have demonstrated before the judges. And I think that it is reassuring to see that we have a young generation of lawyers who are committed to international law and who also demonstrate a profound knowledge of international law. We have, as I'm sure the entire audience, listened with great interest to your argumentation, and the audience should also know that there is a lot of work before you got here, and all the written submissions and all the stations that you had to pass before you came to meeting room number 4 in the headquarters of the United Nations. We should also bear in mind that the proceedings that you have witnessed are characterized by an extreme time constraint. Before the International Court of Justice, the agents would certainly have had more time. And it's also the fact that if this case would appear before the International Court of Justice, it would be a very difficult case. And if you have participated, as I have indeed, in the Sixth Committee in discussing the rules on the international watercourses, you would understand that I'm fairly familiar with all the different arguments that are voiced in the debate. And certainly there are many different opinions that states would take to the questions that you have assisted the court or the judges to address. I should also make clear to the audience that our task here as judges is not to adjudicate the case, to take a stand in the case presented to us. Our case is only to do two things. First of all, to nominate the best oralist before us, and secondly, to nominate the winning team. We first discussed the question, who should we nominate the best oralist? And here we are unanimous. We found that Fiona Gauntlet had demonstrated a great ability and was able to assist the court both in making her case but also in responding to questions. This decision was unanimous. When we came to the question of nominating the winning team, our task immediately became more difficult. We should again say that our task is not to adjudicate the case. Our task is to find the team who made the best oral advocacy before the case, before the judges. And certainly here we would take into consideration also the difficulties in arguing the case for the respective two parties. It proved very difficult, and here we were not able to make a unanimous decision. As a matter of fact, we came to the conclusion by 3 votes to 2 that the agents for Agistanus presented their case in the best way. Thank you. Could you please be seated again? Well, it is a difficult task that judges have to undertake. But I know also from personal experience that many times it is more difficult to appear before the bench. It was an extremely narrow margin, and I think that both teams deserve our admiration today. It is also a pleasure for me as Under Secretary General for Legal Affairs of the United Nations to wish you welcome to the United Nations headquarters. When we received the request from the Jessup Moot Court competition whether this occasion could take place in the United Nations headquarters, we were, of course, a bit worried. There are many people who have to come into the building, the security concerns and so forth. But we thought that in the year of the 50th anniversary of the United Nations, it would be a pleasure for us to host this meeting, also as a demonstration of the activities that form the 50th anniversary of the United Nations. I had the occasion to address the Congress of International Law a few days ago. And this Congress was an unprecedented occasion in the history of the United Nations. Almost 700 lawyers from 140 states took part in that Congress. And the proceedings from the Congress will be published shortly. I think that this was an important event to demonstrate the role of international law and the common ground or the common language that international law is in international relations. And one of the topics we discussed in this Congress was peaceful settlement of disputes, and in particular, resort to the International Court of Justice. What you have demonstrated here to the audience is how agents would appear before the International Court of Justice and argue a case to be settled peacefully and without resort to force. And of course, this is one of the basic ideas laid down in the Charter of the United Nations. And with these words, I will give the floor to Professor Eghbal, who was asked to say a few words. Thank you for your attention.
Thank you, Mr. President, my distinguished members on the bench. It gives me particular pleasure tonight to be here, and I wanted to thank, on behalf of ILSA, on whose board I serve, the United Nations and you particularly, Mr. President, for having received us as well as you have. It is of particular pleasure for me too because on this bench serves one of the original founders who was there when Jessup was born. I speak of the Registrar of the ICJ, the senior member of this bench next to the right of the distinguished Mr. President. And the only request I have of all those here present and those to whom you come in contact is as you return to your respective countries and as you deliberate questions of development, that you do not take present norms as given gospel, that you question and that you keep in your framework, in your mind, the bigger picture, because there is a bigger picture. And sometimes short-term gains are not necessarily long-term welfare, and you might want to keep that in mind. And other than that, I am very happy to know that there is so much support for the Jessup. May it be there for the next 50 years. Thank you, Mr. President.